You're welcome back. This is Newsfile. I'm going to share some of your comments on the Gitmo 2 issue that we have just discussed with you, and comments from Ibrahim Kopa. He says that, from Tamale, that it was apparent that the erstwhile NDC government flagrantly violated the laws of the country, despite the caution given to it by the then minority and well-meaning Ghanaians. Gorazo in the UK says, please, I need clarity on the word ratification as ordered by the court. It's simple. Take it to Parliament and let them say, we, representatives of the people, endorse this agreement. Simple. So that's the meaning. Eja Adam says that the Gitmo 2 will stay in Ghana till their term expire. The government of Ghana don't have the balls to send them back. Parliament will ratify them. Stop putting unnecessary pressure on President Akufo-Addo to do the impossible. Bonti Benjamin Achime Buakwa says that the lords of the law have spoken. The action is now in the bosom of the government to decide whether to keep or kick the Gitmo guys out in 3 months' time. We are watching. Michael Amening in the UK says that the minority, and for that matter, the whole NDC, are being disingenuous and hypocritical because they don't have the moral and credibility rights in challenging the NPP government to repatriate the Gitmo 2. All right, so those are your views and comments shared. Thank you very much. They are always welcome. And again, I'm trying to see if we can box two other issues together and deal with them. I understand that we are likely to do an extended version of the show. So let's see. We should be able to treat the law school matter separately and then deal with the commission and Chachuchikata. It's not really Chachuka, it's NIB case together. Now, in the commission sole judgment death commissioner case, Justice Apau, and people are asking questions. If your peers will deal such a hefty blow to you on what you have done, will you still have the moral right to sit in the Supreme Court as a justice of the court? These are the questions that people are raising, that he is one of them, and they have declared what he did as unconstitutional. And this one too, there were 7 judges, and there was no dissension in this matter. It was unanimous. And this is what they said. That is the Claude Opong versus Attorney General. It's a lawyer who went to court to say the Judgment Death Commission's work has problems. Now, this is what the court said. The action, and this is a certified true copy of the orders. The action herein succeeds in part, and it is hereby declared that all the portions of the findings, recommendations, and statements made by the sole commissioner in the report of the Commission of Inquiry into payments from public funds arising from judgment debts and related processes, and the white paper issued therefrom concerning the cases of Alfred Woyomi. Take note of those. Alfred Woyomi versus Attorney General, and etc., and Sky Consult versus Ghana Ports, whereby the said commissioner sought to fault the judge in the adjudication of the said cases and purported to nullify the judicial decisions therein, are unconstitutional, and the same is hereby nullified. So you remember that charges were leveled at judges who sat in the High Court and gave the decisions about some impropriety that they may have gotten into, or wrong law in the manner in which they came to the conclusions. The Supreme Court said the attempt by the sole commissioner to turn itself into a court to review the decisions of the courts are unconstitutional and therefore, as I put it, thrown into the dustbin. And I say, this was to get us money. What has it ended up doing to us? It has rather cost us money, hasn't it? And then finally, we had the Supreme Court also ruling that the $60 million judgment that had been given by the High Court, affirmed by the Court of Appeal against NIB about some promissory notes. If you remember the famous Charles Jima matters and questions about rice importation and all of that in 2007, well, the court says NIB can now breathe an air of freedom. They don't owe the companies involved a dime. In fact, they were slapped with a cost of 500 Ghana cedis. Mr. Chachichiketa asked for 600 Ghana cedis. I start with Yao on this matter. Yes.
Thank you very much. I think we need to put, especially the Judgment Debt Commission, need to put it in context.
Right.
So under our Constitution, Chapter 23, states clearly that the President may establish a commission of inquiry to go into or inquire into any matters of public interest. Parliament may also request the President to do so, and the Council of State may advise the President to do so under Article 278. And it is also stated that the decisions of the Commission of Inquiry may, subject to the existence of certain, if you like, conditions, become the judgment of the High Court and appealable to the Court of Appeal. And so, even though it is not a High Court, a court per se in the hierarchy of courts, its decisions, depending on the occurrence of any of the conditions stated under Article 280 and so on, can become the judgment of the High Court, especially where the white paper has affirmed adverse findings made by the Commission. And that is why pronouncement of the Commission should be treated very seriously. Also, when the Commission finds one, Commission's adverse findings finds one to have engaged in any act against the security of the state, stealing or misappropriation of state funds and so on, you can, even within a certain period of time, be barred from becoming a member of Parliament, for example. Yes. And Article 94 spells that out as well. And even holding a public office. And so when such findings are made against an existing judge, they are very serious findings indeed. Because even if the person may continue to be in public office, he may not be promoted. Because the adverse findings of a commission of inquiry, which has been accepted by a government white paper, will be hanging on your neck.
Particularly, they are not appealed upon 6 months.
Yes, and it will lapse. And so that is why I was happy that once again, Kwaku's new activists, not spectators, also went to court last year and put before the Supreme Court that a commissioner has made these findings, adverse findings, against not just a judge, but the decision of a judge, a High Court judge for that matter. And that would tighten up to the concerns some people have raised. I think that once again, we need to just be thankful to God that, as I always say, if He never gave us any gift at all, we don't only have an independent judiciary, but bold and independent-minded judges who will determine matters without fear, favor, ill will, or affection. It doesn't matter even if you are one of their own. I mean, just last year or the year before, Superior Court judges were dismissed. They went to the Supreme Court. They still dismissed their matters.
There are people who really thought that because this matter concerned one of them, nobody should be hopeful.
Then that is why I tell people, go to court. When people say that the laws don't work in Ghana, I say go to court and see how the laws work. I mean, we have judges who will look into the face of one of them and say that you did what is wrong. The General Legal Council, which we'll be coming to, is composed of, I think the Chief Justice is even the President.
The former Chief Justice as well.
I remember one of the radio stations called me and said, so lawyer, don't you think that with all these big lawyers on the General Legal Council, and for them to get this plain constitutional provision wrong, is this not a slap in their face? He said that, even though he spoke to me in Cuba, I said that in English. And I said, no, I mean, first of all, the laws are like a coin. Depending on which side you see, you will get a different understanding. Again, don't forget that.
So again, in that case, the expectation was that because it concerned them, in this case, not only one of them, but a good number of them,
yes.
Professor Kweku should not have expected that anything good will come out of it.
And you see, that is why we have to commend the judges. That elsewhere, these expectations from these people, reasonable though they may have been met.
Okay.
But in this country, and this is a clear signal, that not only would they give a decision against the executive, as they did in the Gitmo 2 case, not only would they give a decision even against an institution like the General Legal Council, but if one of their own, it doesn't matter. We know they relate very well. They are friends. I'm sure even after the judgment, they will still meet and greet each other in a very friendly way.
Right.
That is the kind of spirit I want Ghanaians to just imbibe, that when there is a disagreement in the society, no matter how small or big you are, go to court, you get justice.
Let me hear Kweku on looking at it not from, with the legal, approach. The conclusion, therefore, is that this commission was sheer waste to start with.
Well, I'm not too sure. See, the Supreme Court's ruling, was it restrictive or restricted to just the two cases you've mentioned, Woyome, or was it a general indictment of the commission's work? I get the impression they were talking of two aspects. So if that's the case, then we are unable to draw the conclusion that it's a comprehensive indictment of the commission's work.
Okay.
For that matter, am I understood?
It is the case that those are the matters that were brought before them.
That's right. So it would be difficult to draw the conclusion that perhaps this is a complete annihilation of the work of the commission. Because there are many other findings and recommendations the commission made, some of which I have my own difficulty with, if you recall, especially on the judicial matter, But what is it that the Supreme Court is dealing with? I'm dealing with the Woyome angle first.
Right.
I don't really know much about that side. I've taken a look at the reports, what the sole commissioner did on the Woyome case.
Right.
Of course, they didn't invite Woyome.
No.
Woyome presented documentation, which was examined. And, to be honest with you, virtually everything in the report here was already known. And the total effect of the Judgment Deaths Commission's conclusion was rooted in the review decision of the Supreme Court.
Okay.
On the Woyome case.
Right.
He went on to talk about how the High Court gave out the default judgment that he thought was not properly done, how the High Court imposed the consent judgment on the parties and all that. Those were not necessarily part of the Supreme Court thing. But it concluded the same way the Supreme Court concluded, that Woyome was not deserving of that payment and that the payment was fraudulently procured. So I'm asking myself, and this is an unindicated submission, what is it that the commission did that the Supreme Court is nullifying? Is it his commentary? Is it his analysis of what had happened also?
You are saying so because the Supreme Court appears to have confirmed.
Exactly, and the commission actually rooted. If you go, you read it, it talked about the review was rooting after making all those commentaries, which in a way also indicted the High Court and all the rest. It came to the conclusion that based on the review decision of the Supreme Court, so and so and so is the conclusion. Okay. So really, I'm confused as to what exactly.
Just about the commentary.
Okay,
it
says again. Let me read again what I read. Let me read again what I read earlier.
Yeah.
It says that the
can be critical.
The inquiry into payments from public funds arising from judgment debts and process and related processes, and the white paper issued thereon concerning the cases of Alfred Woyomi versus the Attorney General et al. And Sky Consult versus Ghana Post, whereby the said commissioner sought to fault the judge in the adjudication of the said cases and purported to nullify the judicial decisions therein are unconstitutional, and the same is hereby nullified.
Which judicial decisions? Specifics? Because those decisions I read here, for me, what I see in this report
so
was
you want
like
to read the judgment.
It was important, but it was like rehashing what the Supreme Court had done. Read this report.
For example,
and
the
let me
commissioner
finish.
has said that he ought not have gotten the default judgment, which Woyomi got first.
Yes.
You know, he got the default
Yes.
judgment, which began the negotiation
Yes.
to pay. He ought not have gotten
Yes.
it and faulted the judge
Yes.
in the process.
Yes. You see, by the Supreme Court, if you deal with the review decision especially, it even took on lawyers, judges, and things for not being meticulous and diligent.
So they are criticizing themselves.
Yes. Okay. So, impliedly, what the commission said about those lower courts is something that essentially had been captured by the Supreme Court's own decision.
So for technical reasons, they can do that, but a commission cannot do so.
So that is the extension. That is the kind of education I want out there.
I think
that this is the line. I haven't seen the judgment.
They said that by even applying ex parte for that is too dangerous for lawyers and their litigants or non-judges to make such adverse comments and determine which decisions of the court they should comply with.
Okay.
And that the procedure is to appeal, which is what has been done up to the Supreme Court.
Right.
And especially when the effect of the adverse findings of a commission of inquiry are very serious. That is why they were saying that the appropriate procedure is to link to what you said.
Yes.
Is what has been done on review.
Okay, so let me come back.
Yes.
You see, I'm reading from the report.
Right.
It says the Supreme Court in its recent decision in the case of Martin Amidu versus Waterville and two others, including Alfred Woyomi, dated 14 June 2013, particularly the opinion of the JSC, affirms the Commission's conclusion that Alfred Woyomi did not deserve the payment of the huge sum of money that was given to him on a silver platter by the Attorney General and the Tri-Court.
Right.
The said payment to Alfred Woyomi was inordinate and at the same time fraudulent. It therefore constituted a huge financial loss to the state. Then the recommendations were this. This commission recommends, in line with the review decision of the Supreme Court, that the state must take all necessary steps to recall that money with interest from recover. Yeah, but they say recall.
Recall, yes.
That money with interest from Alfred Woyomi.
Okay.
For me, that is exactly what the Supreme Court had done in ahead of this commission's findings and recommendations.
All right.
So that's why now you are clarifying as to the fact that the commission itself did not have the mandate to have questioned,
impugn the judgment of a court.
That's okay. The distinction is clear.
Right.
My final point, the white paper. The white paper actually accepted the commission's findings and recommendations in total, except a small angle that they said the commission went further to talk about Martin Amidu's exit, loss of ministerial job. And the white paper said, no, you had no mandate to do so, and you had no requisite evidence also to back what you are saying.
Right.
That's where the white paper disagreed with the commission. Otherwise, really, relative to the Woyomi thing, I don't know. I need to read the judgment.
So, James, it is this Woyomi thing that led to this commission.
Yes.
You see, in the end,
Yes.
it is this Woyomi thing that led to the judgment that commission. So, in the end, pursuant to the Woyomi case, which led to the setting up of this commission, we can't do anything. We can't implement anything. There's a white paper that we can't do anything about.
Samson, I think that Kweku has raised a very critical issue, and in fact, this matter that Kweku has raised has been agitating my mind, and so I'll be the first to concede that having not read the judgment, I don't want to hasten and draw certain conclusions which may not, of course, be supported, of course. But having said that, we need to make a clear-cut distinction between critiquing a judgment of a court when the court has delivered itself. I believe that everybody, including a commission of inquiry, is entitled to critique that judgment. I mean, for us to say that in the name of the independence of the judiciary, we cannot even run commentary on judgments of the courts when they have delivered themselves would also amount to an affront.
That's not what they have said.
No, that is my position. That's not what I'm saying. I'm only making a point that looking at what has transpired, I mean, in the face of the sole commissioner's own report, because what Kweku just read from the report does not seem to me that the sole commissioner sought to nullify decisions of the court or set them aside. My own view is that what the sole commissioner did was to critique the judgment of the court, the default judgment.
All right.
Question to ask is whether as a country, as a people, we can criticize decisions of the court after they have delivered themselves.
They themselves have said
as a lawyer,
you can criticize no matter how violently.
And so my question is, how does the issue of setting aside decisions of the court or nullifying them arise?
The commissioner has said in the report specific instances where it said the court had done something it shouldn't have done. The court did this and it shouldn't have done. If it had done this, this should have ended in this.
Yes.
It granted this application, it shouldn't have granted it.
Yeah, but all those things no longer have effect. By effect of the Supreme Court.
Nullifying the judgment of the court.
You don't get it.
The fact that the sole commissioner says the default judgment, and that if the judge had looked at ABC
the Supreme Court's own decision has virtually,
you
see,
all these seven judges,
yes,
are not really clear what they are doing. Is that what you're suggesting?
That is not what I'm saying.
He must read the judgment.
I must read the judgment to be able to arrive at that conclusion.
They have come to a categorical conclusion.
Yes, so that is why I'm saying that we need to draw a line between, critiquing judgments of the courts and making orders, orders that have the effect of setting them aside.
Great. But let's hear Alex about it so that we go to the next issue quickly. We don't have time. Yes, Samson. Yes.
I would want to be sure of what I want to say by first quoting, although you have, the order of the court.
Okay.
The action herein succeeds in part and is hereby declared that all the portions of the findings, recommendations, and statements made by the sole commissioner in the report of the Commission of Inquiry into payment from public funds arising from judgment debts and related processes, and the white paper issued thereon concerning the cases of Alfred Woyome versus the Attorney General et al. And Sky Consult versus Ghana Post, whereby the said commissioner sought to fault the judge in the adjudication of the said cases and purported to nullify the judicial decisions therein are unconstitutional and same is hereby nullified. So two issues. Was there an attempt by the sole commissioner to fault the judge in the adjudication of the matter? If so, that is what the court is declaring as unconstitutional.
Because they would have made that finding before they come to that conclusion.
Very well.
Right.
Then the second one is
nullification.
The nullification, yes. For the judge in the adjudication of the said cases and purported to nullify the judicial decision. You see?
There was nothing like that, was it?
Sure, no, I'm saying that that purported nullification, according to the Supreme Court, once again, we don't have the full judgment with that. This is just the orders.
From what you know, would they have said this if they have not made the finding to that effect?
That was there. I mean, a lot were said. I mean,
yeah, but did the sole commissioner vary
yes, I was
any
in court
judgment?
fully.
So the point is that from what my learned senior has just said, that there was a finding that the sole commissioner purported to
First to fault
the judge,
and second to nullify.
Justice Tanko, who presided, who is now at the Court of Appeal,
right,
and also nullified that decision of the court.
Which one? Which decision?
In respect of the Woyomik.
Yeah, which one? Which aspect of the Woyomik decision?
It says
all the judicial decisions. So, in other words, what the court is saying, and what the Supreme Court is saying. The operative word
is nullified. Which decision was nullified by the sole commissioner?
Purported to be nullified.
Purported.
Yes.
So
yeah, which one?
Okay. So whatever recommended, you have the
report is just like
whatever portion of the report that purported.
You see, let's look at the basis.
To have nullified.
Sorry, can we move on? Can we move on?
I need information.
Yes. Okay, thank you.
Was so declared as null.
We will not extend this. If in some other time we have all of us have the judgment, and you want to read it, then we can read and continue. But can we quickly touch on this other issue so that we can make progress to the next?
To conclude, I think that what the Supreme Court was trying to say was that, look, the sole commissioner perhaps has a coordinate jurisdiction. The High Court, the High Court that made the decisions. The sole commissioner was not sitting as an appellate court.
No.
Therefore, it couldn't have.
But it didn't nullify that decision.
No, but that is what the Supreme Court
criticized it.
Yes, but what the Supreme Court is saying, you see, what the Supreme Court is saying is some portions. Yes, what the Supreme Court is saying is that the outcome of your findings, whatever you have said, purported to.
Thank you.
That job has been done by the Supreme Court itself.
Thank you. So can we do this? I want us to do this quick, so we take a break and return to do, because we have just we have very limited time. Now the matter of the NIB and 60.
It's important we deal with it in extension.
Because
this is a very critical matter.
What else do you want to say?
If it's not checked, the executive will appoint.
What else do you want to say? When continuously you are saying that you don't have the judgment, so you are disabled.
No, but we need to clarify the principle. Yes. The principle here is that a court of coordinate jurisdiction, from what they are saying, cannot attend.
Not only that. Let me say this.
You can't even equate the sole commissioner to a coordinate jurisdiction with the High Court.
Not only that, they were worried that if care is not taken, the executive will appoint commissions of inquiry to interfere with the administration of justice, the work of judges. That is very significant.
So generally, what does that tell us?
Were not pending. The courts had dealt with them.
No, the commission finds
generally
to become
judgment of the court.
That argument could hold.
But they also become judgment of the court when certain conditions
for
are
our viewers and our listeners. Alex, what does this tell us? The use of commissions of inquiry. If they will do their work and in the end, it will be subject to a court throwing it away.
No, not necessarily. You see, to the extent that they will act within the mandates of the appointment, fine.
Okay.
But in so doing, you should know that you are walking on a slippery ice.
Right.
Be careful not to interfere with the justice delivery system. That a court has made certain orders, same is subject to appeal or review by an appellate body. You cannot purport to now say that, look, this judgment, I'm setting this aside.
Right. So let's wait.
You can make your findings, but don't go and touch on a judgment that has been pronounced.
Right. So I'll say let's do what Kweku cautions and James and yourself suggest. Let's have the judgment so we know the specific findings they made and the conclusions which led to these orders.
That relieves that
exactly which led to these orders.
I'm confused.
Right. Okay. You're confused.
Yeah.
Okay. Now let's get